I'm Sergeant Christy Mysinger from the Lake County Sheriff's Office, and today I'm going to talk to you about your Miranda warnings. When a person is arrested or is the suspect of a criminal investigation, there are certain inalienable rights that apply to you. These rights come from the United States Constitution, specifically the first 10 amendments of the Constitution that are also known as your Bill of Rights. Now, while many of these rights apply before, during, and after an arrest, or while being investigated for a crime, there are two specific ones that the courts have deemed over the years as being absolutely crucial to an accused person during an interrogation or questioning phase of an investigation. The U.S. landmark case, Miranda v. Arizona, was a 1966 case that made it to the Supreme Court. From this case, the Miranda warnings were born. These are your Miranda warnings. Many of you have heard of these on television. You watch it on Cops or seen it on Criminal Minds or CSI Miami. Pretty much all Miranda cards are the same. They come from a pre-printed text. We'll go over them. You have the right to remain silent. Anything you say can be used against you in a court. You have the right to talk to a lawyer and have for advice before we ask you any questions, and to have him with you during questioning. If you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. If you decide to answer questions without a lawyer present, you may still have the right to stop answering at any time. You also have the right to stop answering questions at any time until after you talk to a lawyer. Those are the specific warnings. But we're also required to make sure you understood those warnings. Therefore, we have affirmation questions. And those questions are, do you understand each of the rights that I have explained to you? And we must get a yes or no statement from you. If we don't, we'll go back and explain it. Have you previously requested any law enforcement officer to allow you to speak to an attorney? This is important. If you have, I need to stop right then and there. Because if you've already asked to speak to an attorney, and maybe a street officer asked you and then an investigator didn't know that, you need to tell us, yes, I've already asked for that. Oops, stop. With these rights in mind, do you wish to talk to us now? If you say yes, what you've done is you've waived these rights, and we can now speak. If you say no, I want to keep quiet, or no, I want to speak to an attorney, at that point all questioning must cease. So where do these rights come from? The Fifth Amendment to the Constitution and the Sixth Amendment Constitution are where our Miranda rights come from. Now, while they cover a lot of ground, it's these specific sentences that give us those rights. In the Fifth Amendment it says, nor shall be, this is speaking of a person, nor shall they be compelled in any criminal case to be a witness against himself. You've also heard of this, it's called self-incrimination. How many times has anybody seen on TV where somebody says, I plead the Fifth in court? They're talking about this specific sentence of the Fifth Amendment, to not incriminate themselves. This is your right to remain silent. Under the Sixth Amendment of the Constitution, you have the right to the assistance of counsel for your defense. You have the right to seek the advice of a lawyer and to have that lawyer present so that you don't do something that can endanger yourself. There's your right to a lawyer. But when are the Miranda warnings applied? They're applied when there's custody and interrogation, and you must have both. You must have both custody and interrogation. So let's talk about the first one, custody. Custody occurs when you're either handcuffed, you're in a patrol car, you're in a police station, or you're anywhere where you do not believe that you are free to leave. If David decides to get up and start to walk out of the room, and I walk over to him and I say, sit down, David, I'm not done talking to you. And he sits down. It's because he thinks that if he doesn't do what I asked, I'm going to arrest him or he's going to be in trouble. Does he believe at that time that he is free to leave? Probably not. So just because you're not handcuffed or you're not in a patrol car, sometimes you still might have a reasonable belief that you're not free to go. That's custody. Interrogation is when we ask you direct questions about a crime. Now, if you're the witness, you're not being interrogated. You're simply being questioned. But if you're the suspect, and I'm asking you, did you stab that person? That's a direct question about a crime. So in recap, Miranda v. Arizona is where we get our warnings. They come from the 5th and 6th Amendment to the Constitution of the United States, and they must have custody and interrogation in order for them to fly. Any questions?